folks, and welcome back to Conveyancing. This is the video series for Contract to Settlement, and this is part one of the video series. Today we are going to be having a look at a number of different concepts that will take us from execution of the contract through to the time of settlement, and then in part two we'll be having a look at matters relating to settlement specifically. So on the agenda for today we will be having a look at a few big ticket items, the transfers that you need to prepare, the objections to the form of conveyance, so we need to distinguish that from objections to title, caveats and priority notices, outgoings, and of course that old chestnut, time and time being of the essence, and extensions. So looking first at the issue of transfers, Queensland has been slower, surprise, surprise, than the other states, particularly in New South Wales, Victoria, I think South Australia and Western Australia, that have all jumped on board to basically accept the mandate to go 100% paperless in conveyancing. There is a timeline of the state's mandates and when they need to go paperless by on the PEXA website. If you search for industry milestones, I think you can find that. Certainly not mandatory in Queensland at the time of this video, although paper certificates of title have gone, so I guess that's one small step towards a paperless system. So obviously we can still certainly do paper transfers in Queensland. I have been speaking to some conveyancers and real estate folk, and they tell me currently in Queensland we have around 60 to 70% of our transfers that are done electronically at the moment. And one real estate agent commented to me, you can't stop it, PEXA's taking over. So I guess that represents some of the feeling amongst industry professionals. Not all of them are running towards a paperless system. Some of them are quite happy with the paper transfer system. It may take a while unless we get a push along by virtue of some legislative movement there. So that's the overall picture. In terms of the old paper system, clause 5.2 of our Houses and Land Standard Contract requires preparation of the transfer documents by the buyer's solicitor. So the buyer's solicitor will be the one that types everything up. The phrase transfer documents is defined in the standard terms clause. You can see there 1.12 double K means the form of transfer and any other document to be signed by the seller for stamping and registering the transfer. The seller has to deliver the buyer unstamped transfer documents capable of immediate registration, and that phrase can cause some angst. We'll talk about that in just a moment. So usually in practice you'll have the seller delivering to the buyer transfer documents for stamping. If you want to have a little look at the forms that are required, so we've got the Form 1 transfer there, the Form 24, and there is a Form 25 that you also need to think about in terms of foreign ownership, if that comes into play. We'll be talking about the foreign ownership arrangements later on in this video series. So they're the pieces of paper that you need to shuffle around if you are going to be doing a paper transfer, and hopefully we won't be doing all of that too much longer. In terms of e-conveyancing, we'll talk about this a lot more in the next video series, so in part 2. But just looking at the issue of transfer and the work that needs to be done in preparing the documentation there, clause 11.2 of the REIQ standard form contract deals with conveyances that occur electronically, and instead of preparation of the transfer documents, the paper transfer documents, you have the joint obligation between the parties. So as opposed to the paper system where it's the buyer's responsibility to type everything up, here in the electronic world we have a joint obligation under 11.2 to ensure that the electronic workspace is completed. That means you need to ensure that all of the electronic conveyancing documents, that's a defined term, and financial settlement schedule are completed and digitally signed off by the parties as required. Helpfully, electronic conveyancing documents in clause 11.7 says that it's as defined in the Land Title Act. Helpfully, in the Land Title Act, section 14b says that an electronic conveyancing document is a document lodged electronically. A little bit of a circular definition there. Realistically, that means that you're going to have to prepare your transfer document. You can see a screenshot there from a PEXA transfer on the left hand side there, and your forms 24A, 24B and 25. So similar to the paper system, but obviously all done on screen. No trees have to die for that exercise. The buyer has to ensure that stamp duty has been assessed and the assessment number has to be included in the workspace. So that is a short little, I guess, introduction to some of the things that you'll need to do when you're completing an electronic conveyance. As I said, we'll deal with that more in the next video series. So that is the issue of transfers. Now, you'll know in our discussions from the video series on seller disclosure that often there will be items that are revealed after you've done your searches if you're acting for a buyer, and they may well lead to objections to a defect in title. And you will recall a defect in title is an assertion that there's some kind of problem with the seller's title to the land. They can't give perhaps unencumbered title to the land, so there might be, undisclosed defects there, leases and so forth. They need to be distinguished from objections to conveyance. Now, an objection to conveyance is an objection to the form of transfer. The form of transfer, rather than a defect in title, there's a defect in the form of transfer. What's that all about? Well, under section 61(1)(d) of the Property Law Act, we have this implied term that every purchaser is entitled to have objections to the registration of transfer removed by the seller. So if there are problems there with obstacles that may be raised to registering the transfer, then that will be an objection to conveyance. Because the 61(1)(d) implies this term into all contracts, then breach of that is going to be breach of a term of the contract. Usually, if there is something nasty that's preventing registration of title, then it'll be an essential breach for which the buyer may terminate. Now, an objection to conveyance, for example, if there's a caveat on the title, exploration of the reason for the caveat may well reveal a defect in title, but an objection to conveyance won't always encompass defects in title. So you'll see in the text that they talk about various different common objections to the form of conveyance. As I say there, this can often be a caveat that has been lodged. There might be an unregistered power of attorney there that's causing issues. where you have a transfer that's not capable of immediate registration, and this one may well crop up where you have the seller of the property not actually being registered on title as the owner of the property, as the proprietor. And this can happen where you have a property that's been sold to a buyer. There's the original seller is registered on title. The intermediary buyer obviously is not yet registered on title, and then that buyer on sells to a second subsequent buyer. So in that second contract of sale, obviously the interim buyer is not yet registered on title, and so they don't have title to pass, legal title to pass on to the ultimate buyer. So if the interim buyer was to complete a transfer to the ultimate buyer, that ultimate buyer would not receive a transfer capable of immediate registration, would they? Because that seller that they're buying from is not yet registered on title. Now these things can be solved usually, for example, where you've got a series of contemporaneous settlements that happen. However, as the ultimate buyer, what you would need to do is get a transfer direct from the original seller that was registered on title, so that you could have your transfer capable of immediate registration. The death of the seller or buyer can also cause problems for objections to conveyance. I'll leave you to flesh out those concepts further for yourselves in the text. The next issue we need to look at is how the buyer will protect themselves between contract and settlement, and caveats and priority notices are the big ticket items here. In terms of caveats, you'll see in paragraph 6.4 of the text there is a rather handy-dandy list of features of caveats as compared to the features of what used to be called settlement notices, which are now called priority notices. We'll get to priority notices in just a moment. But the main features of a caveat are that pretty much anyone claiming an interest in a lot can apply to register a caveat under Section 122 of the Land Titles Act. Under Section 124, the effect of it is going to be to prevent subsequent registration of interests upon that title. There are some exceptions there, which I'll leave you to flesh out for yourselves. Some of the exceptions are actually listed in that list. Listed in the list. They are set out in the list that I referred to in the text, so you can check that out. Under Section 126.4, a caveat is only going to last for 3 months, and then the person that has applied for the caveat needs to institute proceedings in order to have the dispute over the title resolved. There are some non-lapsing caveats, for example, caveats that are actually lodged by the Registrar of Titles. You'll also recall in our earlier discussions on instalment contracts under the Property Law Act Section 74 there, if you are the purchaser under an instalment contract, a true instalment contract, where perhaps your interests might be vulnerable because you're making all these payments without being entitled to receive a conveyance in exchange, then any caveat that you lodge to protect your interests there will be non-lapsing. So that's the issue of caveats. If we look at priority notices, now this is where your text needs a fair bit of updating. You can pretty much cross out the section on settlement notices, and this is the stuff that you probably should put in instead. Under 139(1) of the Land Titles Act, a priority notice can be lodged by a person who is or will be a party to an instrument that is to be lodged and will affect the interests regarding that lot. Again, like a caveat, it will prevent later registrations on title, but there are, again, like caveats, a number of exceptions. Note that a caveat is one of the exceptions. So you can't lodge a priority notice and think, haha, no one else will be able to caveat their interests on this title, because priority notices are not effective to prevent that. Under Section 142, a priority notice is going to last for 60 days. You can renew it for another 30 days. However, after that, it will expire necessarily, no further extensions. If, in fact, the instruments that you refer to in lodging the priority notice are lodged earlier than 60 or 90 days, then the priority notice will lapse when the instrument entered on the notice itself has been registered. Okay, so that is caveats and priority notices, and we've passed the magical 15-minute mark. So I'll leave it there for this particular video, and I'll catch up with you in video 2 in the contract to settlement video series. Bye for now, guys.